Ladies and gentlemen, good morning. I'm really glad that I can start. I hope that I can start slowly with my presentation of our panel, which is focused on administrative law, concretely on administrative substantive law. When we talk about administrative offenses in environmental law, we often focus on administrative procedure. And it's normal because it's mainly about how inspections are done or how sanctions are imposed. But what truly defines the effectiveness of the whole system is the substantive law itself. And I also believe that without a clear and coherent substantive regulation, even the best procedural law cannot guarantee justice or consistency. And that's the reason why we must focus on what the administrative substantive law means in this area. In our panel, I'm going to show you my comparative presentation, but after that we are going to discuss with my dear colleagues, with Dr. Tomáš Bojar-Fijałkowski from Poland, from Közép-európai University. Welcome. And also with Dr. István Olajos, Associate Professor from University of Miskolc, Hungary. In my presentation, I try to focus on the most important topics in administrative substantive law. In the first part, I want to tell you something about administrative powers in our Visegrád countries in this specific area of environmental protection. After that, I'm going to tell you about differences and also about common things in regulatory framework and types of administrative acts. After that, I'm going to tell you something about administrative offenses and boundaries with criminal law in each of our countries. And after that, in the final part of my presentation, I'm going to tell you something about sanctions, compliance, and also enforcement practices in this administrative law area. So, in the first part about administrative powers in environmental protection, I think that it's very important to focus on structure of environmental administration, on central authorities, ministerial competencies, which are very similar, but there are also some things that are not the same. There are some differences also in the area of regional and local administration. There are also some substantive law principles that defines what the public administration in this area really is. And also I want to tell you something about supervisory and enforcement mechanism. So what about the general structure of environmental administration? We can say that in all Visegrád countries, environmental governance follows a multi-level administrative structure, combining central, regional, but also local authorities. But there are differences also in the administrative power, because there are some, we can say, self-government powers in some levels, but mostly state powers in this area. In general, we can say that ministries of environment played a leading policy-making and supervisory role, but they are not the same. Actually, some parts of protection of environment are governed by other ministries, not only ministries of environment, but also some sectoral ministries like ministries of agriculture, industry, or health. But they are also on central level, complemented by specialized inspectorates or also the other types of administrative bodies. What is we can say the common thing for every country, that are the principles of legality, decentralization, or specialization, which support distribution of competencies. Despite some formal similarities, we can say that fragmentation and overlapping competencies remained a shared administrative challenge for every our country, and the reason why we need to talk about some challenges and things that need to be changed in the future. What about central authorities? Minister competencies in Slovakia. The Ministry of Environment supervises also district and regional offices. Also some other agencies of administration of environment. But on the other hand, there are some problems in sharing competence with other ministries, like Ministry of Interior, in governing these district and regional offices. In Poland, there is the Ministry of Climate and Environment that coordinates with central agencies such as General and Chief Inspectors for Environmental Protection. In the Czech Republic, the Ministry of Environment leads policy, while Ministry of Agriculture and Industry retain sectoral powers. In Hungary, competencies are shared between the Ministry, Deputy State Secretary, and the Pest County Government Office as national authorities. But what about regional and local administration? On regional level, Slovakia and the Czech Republic, there are some regional kraj offices which exercise extensive first and second instance powers in permitting and sanctions. In Poland, there are voivodeship authorities and marshal who both governmental, that means state power, but also self-government authorities competencies. And in Hungary, county and district government offices perform territorial environmental functions. In local level, it's even more complicated because there is a strong authority of local self-government. Municipalities across all four countries perform both delegated state administration, but also self-government itself. It sometimes causes some problems in overlaps or unclear accountability, what really state administration is, or whether it is state power or it's self-governance in this area. There are some important delegation principles in coordination. For example, there is a principle of legality which ensures that all administrative actions are grounded in law. For example, in Poland or also in the Czech Republic, decentralization and subsidiarity promote decision-making close to citizens. It means that there are strong self-government bodies in these two countries. On the other hand, in Slovakia and in Hungary, there are stronger delegation and the concentrating principles in the state administration that allows central governments transfer specific information powers downward, but still in the state administration bodies. There are also some supervisory and enforcement mechanisms. For example, in Hungary, there are strong hierarchical supervision by the Deputy State Secretary and Ministry oversight. On the other hand, in Slovakia, there is vertical control between ministries, state agencies, and district offices in region and the others. So there is a strong system of vertical control. On the other hand, in Poland, there is emphasis on subsidiarity and cooperation among administrative tiers, but there are also some national funds supporting compliance. In the Czech Republic, regional offices, they act as key decision makers and appellate authorities, ensuring procedural coherence but is also within a decentralized framework. The second part of my presentation, I want to tell you something about types of administrative acts, about differences in these administrative acts, also in monitoring, inspection, enforcement, and preventive and policy instruments. In all Visegrád countries, there are both normative and individual administrative acts. We can say that public administration in protection of environment is quite authoritative. There are not a lot of administrative contracts or something like that, which are mainly specific for the other parts of public administration, but here in protection of environment, it is not so strong. So we can talk in general just about normative and individual administrative acts. Normative acts, they exist in many forms. For example, like governmental decrees, ministerial regulations, and local ordinances, which we can say establish environmental obligations. On the other hand, individual acts, they are like administrative decisions, permits, authorizations, prohibitions, and many others. But there are some specifics, and I've chosen two, for example, for the Czech Republic, which also applies measures of a general nature and binding statements in EIA and integrating permitting. And for example, Hungary, in the Environmental Protection Act, that codifies preventive, restorative, and cooperative duties directly under statutory principles. There are some things that are common also in monitoring, inspections, and enforcement. For example, Poland and Slovakia, there are some inspection-based enforcement with protocols, corrective and sanctioning measures. In the Czech Republic, there is a multi-level administrative supervision via regional and municipal offices. In Hungary, there is continuous monitoring and data collections through National Environmental Information System and the other system, Hungaromet. We can say it or conclude that enforcement instruments, they include compliance orders, supervisions, increased fees, and administrative fines. Also, we may focus on preventive and policy instruments. In every country, due to international and European law, there are some prevention and control systems combining permits, EIA, and also best available technology. They exist in every country, but there are some differences in the way how they are done. For example, in Poland, there is precautionary decisions on environmental conditions before investment. For example, in financial security for hazardous activities. In Hungary, there are codified principles of precaution, prevention, and restoration. And for the Czech Republic, we may focus on limiting exceptions for public interest projects. There are also absolute bans for certain harmful activities. In the next part of my presentation, I want to focus on classification of administrative offenses, on the typology of these offenses, but also on things like administrative liability. We can say that in every Visegrád country there are something like general fault-based offenses, but most important there are objective offenses with strict liability that dominate environmental law in every country. Liability arises from irrespective of intent, and we can also name that they are hybrid offenses that overlap with criminal liability. Administrative liability, in general, it is mostly objective, but there are also some administrative in this area. But there are also some administrative offenses like priestupky in Slovakia, which are created on subjective liability. For example, in Poland and Hungary, administrative liability is predominantly objective. Also, in the final part of my presentation, which is going to end really soon, I want to tell you something about sanctions. In general, for every Visegrád country, administrative fines are the most important type of sanctions, but there are also some others like suspension or withdrawal of permits, orders to remedy damage, and also some temporary prohibition of activities. Due to lack of the time, I just want to focus on two examples. First one is Hungary, that diversifies fine system in many sectoral laws, but also on Poland there are fines for violation of reporting or permitting obligation, and I found it quite interesting in our comparison. Boundaries between administrative and criminal liability are different in every country. We can say that, for example, in the Czech and Slovak law, it's based on threshold defined by material harm. But in Hungary or in Poland, it's not the same, because there are some cases where nebis in idem is restricted in this environmental law due to restorative goals, and it may exist both liability in administrative law but also in criminal law. We can say that nature and function of administrative sanctions, the key principle is the polluter pays, and it's very important in most administrative liability cases in this area. Objective liability, it is contrast with culpability-based approaches, like in Czech Republic or Poland. But all systems allow discretion to adjust sanctions to circumstances. Very important thing in this topic of sanctions is also proportionality and discretion in enforcement. We can say that proportionality operates as a unifying rule. Authorities enjoy administrative discretion guided by statutory limits and aggravating. And due to the lack of time, I want to finish with my final slide. What are future perspectives and conclusions in this area? I think that very important is the need for transparent environmental enforcement, also in institutional consolidation. I prepared also my question for my dear guests about structure of administrative bodies. I think it's a very important question today in every country. Also, I want to focus on procedural consistency and data-driven enforcement in this area, which is really goal in today's world, and shift from reactive to preventive inspection model. And I think that's the reason why administrative liability is going to be more and more important today. So thank you for your attention for my first part of our panel. And now I would like to present a question for my dear guests. I want to present question for my guest from Poland. First one is, considering the current fragmentation of Polish environmental administration, do you believe that merging institutions such as many of them would generally improve the effectiveness for environmental enforcement, or could it risk weakening regional expertise and control? And the second one is, in Polish environmental law, administrative liability is often based on the principle of objective responsibility. How do administrative authorities ensure proportionality in cases where penalties are imposed without proving fault? For instance, when the violation results from technical or procedural errors rather than deliberate misconduct.
Thank you very much, Chairman, for such interesting questions. Thank you for invitation to this wonderful event here in Budapest. I should say, Juno Podkiva, no? I believe this is the good morning in Hungarian. So the first question is related to the structure of administration. And also when listening to your introduction, I would say that we do share something here in common in the V4 countries. And I would say that we all share Austro-Hungarian administrative law culture and background with some Soviet flavor, and so far 20 years of European law unification. Of course, the unification is not for the structures of administration, but for material law. It does influence somehow. We do have a lot of different administrative bodies in Poland which are responsible for environment, and this is the local authorities, the self-administration on the level of community, county, and the region, because we have 3 levels of the self-government, and we have several governmental administrative bodies responsible, and you have the letters representing them here also on the slide. So I would say that that's the general problem and the general question of the structure of Polish public administration, but only the governmental administration. The self-government is relatively new structure. I say relatively because it's 26 years now when we have this 3-level structure of the self-government, but it's very effective. It is being changed during election every 5 years, and it's dynamic. And the leaders of the self-governments do answer the requests and the needs of the people, also in the terms of the quality of the services they provide. Not necessarily in case of the public administration, the governmental sector. Please notice and realize Poland is 220,000 kilometers square. So this is the size like 4 times Czechia, 6 times Slovakia, or 3.5 times Hungary. And we have 16 regions. The smallest one is 12,000 kilometers square. So this is like 1/4 Slovakia. The biggest are 27,000 kilometers square. So this is like 1/3 of Hungary. We have 16 regions like that. And we have the general director of the environmental protection with its regional structure in every region voivodeship, but also the inspectorate, a general or a chief inspector of environmental protection with the structure in every region. You would say that's a lot in every region, but you have the regions of 27,000 kilometers square, and they are not present in the counties or communities. So their effectiveness also from this reason is not so great. I've asked once the people managing in our region where I live, the director of the environmental protection and the inspectorate, why they could not merge. And the answer of the director was because the directorate does the management of environment and the inspectorate does the control. As far as I know from the theory of management or business administration, the control is a part of management. This is just the result of some political decisions. I could tell you the details about that, but there is not a time. It should be all changed. They should be merged because now there is a duplication of activities, different interpretations, communication problems, the lack of common enforcement approach, the budget shortcuts, and the duplications of supply units. So I'm not saying that the specific unit for the control would be merged with the specific unit of a different profile, but they all have the human resources, and other administrative sections which could be simply combined. What shall be done, or what would be the result? That would be the improvement of effectiveness, better use of resources, and the greater transparency for the customers. Because now the customer, no matter if this is individual or a business, but especially a business, is still going to 3, 4, or 5 different administrative bodies, which all of them deal with environmental issues, because except the specific ones, we also do have maritime administration, which deals with the environmental on the sea. We have the sanitary administration, which is dealing with many aspects of environment as well. So this is a general need for the review of the governmental administration, which was created in Poland in the time when Mr. Stalin was ruling in this part of the world, and it was not really changed since then. It is only multiplying more and more administrative bodies because more and more politicians want to have their own domain. And the second question, if I may, was about the liability and the issue of the objective responsibility. Well, I would say that the administrative body is still quite effective. What I said about the structure does not mean that the people working there are not professionals. They are. But if that was changed, this would create a better working condition for them and for the customers. So the administrative people working in the administrative institutions, they are professionals, and they are able to measure the scope of the violation to fulfill the rule of proportionality, which is in Polish rule of law, in constitution, and in environmental law regulations. So what they take into consideration: the scale of violation of environment, the environmental impact of their action, and the frequency or persistency of the violation, and the degree of the cooperation of the individual with the administration. And they decide then what would be the scope of this penalty. They can even abandon the penalty. It's also possible. So if there was a problem with these actions, this would be seen and verified in the second institution on the administrative field, and then in the 2 levels of administrative courts. And as far as I know, such problem is not visible very often. So the courts, they of course do verify the administrative decision made, but I think the principle of objective responsibility is not the main problem in the decisions made by the Polish environmental administration. And I think this is all I should say now. Maybe you will have some questions in the time of the discussion. Thank you.
Good morning, ladies and gentlemen. I don't like take a lecture, but I like to answer my leaders' questions and so on. The mechanism based independent control generally applies the areas, the public administration, where the authority is required to control the certain type of activity, and only the applicant is responsible for activities are subject and accountable and control. In terms of integrated approach, environmental protection affect the environmental elements and activities that threaten them. The activities are address the environmental users, administrative bodies, as well the state, which is responsible to maintain balance in present, in the future, which alone to bring the legal action and injured party in relation to damage caused in individual elements of the environment and to the environmental protection as a system. Due to the complexity of the system to be protected, which prescribes obligation the 5 elements, land, water, air, and built and natural environment, well as several natural and artification hazards, waste, noise, vibration, radiation, and odor, is not easy to development the uniform control strategy. The Hungarian administrative system has been reformed, with various aspects being enforced within the highly centralized mid-level system. As the component decision-making body, the Environmental Protection Authority is not bound the opinion the advisory body operating with the same office, the free of the consider accent the considers of opinion the organizational department within the same office. Expression its opinion, certain listening procedure as an authority belonging the another office is the mining authority has a much greater role in the final decision because the view of the internal authority, which expresses the opinion informally, possibly by telephone, can be taken account in the same way. The licensing decision made of behalf of the chief magistrate, the head of the government office, but the supervision of more than 10 departments does not allow the actual withdrawal of power. Thus, sectoral considerations are much less prevalent mid-level public administration than the previous specialized authority procedure, so effective restoration of to their administration procedure was justified in order to ensure the transparency of environmental licensing system. And the second question, in order to promote the division, the central administrative level of environmental protection system and the promotion uniform multi-level enforcement of responsibility in environmental authority decision, the primacy of restoration, the joint enforcement of administrative, criminal, and civil liability presuppose the administrative organizer system in which the law is instrumental in nature. The use of the legal instruments at this level allows the demarcation of law, which with environmental concession approach, the synergy of responsibility prevails. The current nature conservation administration in Hungary is centralized the state secretary level of Minister of Agriculture, which has an economic and legal perspective, while the waste and material management of environmental affairs are centralized at the state secretary level in Ministry of Energy, which also has economic and legal perspective. This type of high-level public administration does not treat the environmental protection, which is regulated by uniform regulation in the uniform manner, and regulatory synergy to promote the protection can only be properly enforced the single independent ministry regulated of areas, under the similar protection concept. Thank you very much.
Thank you very much, both of you. It was very interesting to hear your answers. For the end of our panel, I prepared just 2 questions for you if you want to answer. They are mostly general, but I think they are very interesting. First one is, where do you think the line should be drawn between administrative and criminal liability in environmental cases? It's not the first time that we are talking about this topic on our conference, but I think it's very important to look at it also from administrative point of view. And the second one, how can we make environmental enforcement more effective through stronger sanctions or smarter, more preventive tools? If you want to answer, I would be very glad. You can come here.
At the end, should sanctions be smarter or tougher? I have general impression that in Poland, at least, we have very often a problem with executing the sanctions. So making them tougher not necessarily is the solution. So then, obviously, more smarter and more preventive. I'm always bringing as the example many voluntarily systems and programs that individual, especially companies, may introduce for themselves, like the eco-management systems, which can do a lot and keep the administrative far away from having a job to do with such companies and situations. This could be used more often. In general, in Poland, it's not time to make the whole lecture about it, but in general, we can see that the criminal sanctions are not very effective in the system of environment. More often effective are the administrative sanctions, especially the financial sanctions. And even in certain fields and certain acts, the legislator is changing in the time the sanctions, replacing the criminal sanctions with the administrative sanctions, because it's easier to use them and they're more efficient. And what should be the border? I think this should be discussed not in general, but on the field separately of the water law, animal protection, and so on. But there should be the border between the administrative and criminal liability, and the criminal liability in Polish case, it's not effective. The criminal liability should be left for really obvious cases. Because we do observe that there is a problem with law enforcement under the criminal liability. Also, the problem of the prosecutors and the judges, because the prosecutors are not necessarily interested in opening the cases which deal with the environmental crimes. They don't know this field. They're not interested. There is not body, there is not blood, so they don't want to deal with it. That was the case of animal protection in Poland for many, many years. We have the same regulations with the same criminal liability, which was written, I believe, 20 few years ago, and there was always a criminal liability, but the prosecutors were not starting these cases, and if they were starting the cases, the judges were saying, well, nothing really happened. I'm sorry about the dog or the cat, but this is not the issue. What have changed is the civil society 5 up to 10 years ago, which started pushing the judges and prosecutors to really care about that and really open such cases. And and now they do open the cases like that. And the secondly is the positive influence of the new technology, because before, when it was only a testimony of the neighbor that my neighbor is hurting the dog, cat, or any other animal, the prosecutor or the judge was saying, well, one neighbor is not a fan of the other one. I'm not getting into details about the neighbor situation. And now those people do record themselves when they hurt the animal. So this is more problematic for the prosecutor to say, I do not have an evidence, because the evidence is somewhere on the YouTube. So the border it should be there between, and there should be more interest in environmental criminal liability among the specialists of criminal law. But this, for the reason of effectiveness, this should be left for this very strict, like the animal protection, for instance. I think I used too much time.
The first question is, which is the administrative or criminal liability? The criminal liability is the peak of the ice mountain. The other side is the administrative system and administrative liability. It's a very strong and very big question. Take a criminal liability and very, very little and no effective in Hungarian structure in the criminal sanctions, I think. The second one, the environmental enforcement, stronger sanction and smarter. I think the smarter and preventive tools is more effective in the environmental sanctions. Thank you very much.